morning, everyone. I am Masha Muzica. I am representing ACC Middle East and North Africa. And I would like to say a big thank you to Afridi Angell for hosting this seminar. And I would like to say that actually having this seminar is really lovely because it's a sign that the summer is over. For me, it's always been the first sign that the summer vacation is definitely over is first of all, it's start of the racing season with Wadi Shofka race, and secondly, it's the Afridi Angell seminar on the latest developments. So it's a great one. I thank you very much once again for hosting this seminar, and I would like to hand over to Afridi Angell.
Thank you very much, Masha, and thank you, ACC Middle East and North Africa, for organizing and hosting the seminar with us. Good morning, everyone, and welcome to the ACC and Afridi Angell webinar. My name is Samira Mari, and I'm the Head of Business Development and Marketing at Afridi Angell. Our speakers this morning are partners Bashir Ahmed and Stuart Walker, and Senior Associates Abdus Samad and Sulakshana Sinanayaka. We will have a discussion and Q&A on the 100% foreign ownership in the UAE and on restrictive covenants. Before I hand over to Bashir and Samad, who will kick off the discussion with the 100% foreign ownership, I want to remind you to send your questions throughout the webinar in the Q&A space. We will take a few minutes to answer questions at the end of each segment, in addition to having a general Q&A session at the end of the two segments. We will do our best to address all questions received within the hour. I also want to let you know that this webinar will be recorded, and the recording will be shared with all of you and will be posted on our website. Thank you again for joining the ACC Middle East and North Africa webinar, and thank you for the ACC for hosting and organizing this webinar with us. Over to you, Samad and Bashir.
Thank you, Samira. Good morning, everyone. Abdus Samad here from Afridi Angell. This morning, we'll be talking to you first about the changes that have happened to the foreign ownership regime in the UAE. Now, of course, this is a topic that has been written about, spoken about quite a bit over the last 6 months. But a number of key developments have taken place over the summer, and so it would have been remiss for us to not mention them and to not provide this update. Now, to start with, let's look at what the previous restriction was and what's happened to it over the summer. Federal Law 2 of 2015, which concerns commercial companies in the UAE, previously contained a restriction requiring that all onshore companies be owned at least 51% by UAE national shareholders. This restriction has been removed by virtue of Federal Decree Law 26 of 2020. The next slide, please. Next slide. The effect of the statutory changes is now that Emirate-level licensing authorities are given a very broad range of discretion to decide which activities and which types of businesses they wish to allow to open up to majority or 100% foreign ownership within the relevant emirate. This is all subject to a so-called prohibited list of strategic impact activities. These activities include the sectors of security, defense, military, banks, exchange companies, insurance, currency, printing, telecoms, Hajj and Umrah services, Quran centers, and fisheries and related services. I will add that the fishery sectors is the only one that is specifically stated to be reserved for only 100% UAE national ownership. So the position is that outside of these so-called strategic impact sectors, emirate-level licensing authorities can determine which activities and which types of businesses they wish to open up to majority or 100% foreign ownership. Abu Dhabi, Sharjah, and Dubai have now issued lists or guidance in some form on which types of businesses are going to fall within the relaxed foreign ownership regime. Abu Dhabi has taken a slightly different approach to this than Dubai and Sharjah. The Dubai and Sharjah economic departments have issued a lengthy list of specific activities which are now open for foreign ownership. Abu Dhabi, on the other hand, has instead issued a decision setting out which specific activities are reserved for UAE national majority or full ownership pursuant to the prohibited list of strategic impact activities. And the approach taken in that decision is that outside of these specified activities which are off limits for majority or 100% foreign ownership, generally industrial and trading activities are now open for full foreign ownership. So the question then becomes, what can a UAE onshore LLC do to take advantage of the current regime and the much liberalized foreign direct investment law in the UAE? The first step is, of course, to check specifically on the trade license which activities are included, and then to consult with the economic department or the relevant list of guidance to check whether that activity is, in fact, permitted for a full or majority foreign ownership. Now, note here that there are limitations on what is possible for so-called professional activities like consultancy services of all type, like restaurants is a notable and problematic example. These so-called professional activities cannot be included currently on a license for a limited liability company. There are some historic companies that have historically maintained these activities, but the position that the economic departments now take is that professional activities cannot be given to a limited liability company, and so additional restrictions may be relevant for those activities. But the takeaway here is check the license and consult specifically with the relevant economic department to figure out whether the activity you need is on the liberalized regime. Once, and assuming that the activities you need or the business needs falls within the expanded scope of FDI, the first step is really to check also your contractual arrangements with the UAE national shareholder, checking whether notice requirements apply. For example, if you need to give 6-month notice to conclude any arrangements you have, if any payments of any sort are due on termination of the relationship, and what other procedural requirements may need to be followed as set out in whatever your contract is. We've now had experience with moving businesses to 100% foreign ownership in the Emirate of Dubai, and our experience indicates that the routine share transfer procedure is to be followed. This would typically entail initial approval from the DED in Dubai, notarization of the share transfer documentation, and concurrently attending to any external third-party approvals that are needed. Again, this will depend on the activities on the license. And then finally, getting final approval from the DED, and then subsequently updating labor and immigration files to reflect the exit of the UAE national shareholder. The feedback I will add at present, at least in Dubai, Abu Dhabi and Sharjah, is that there are no particular restrictions or special requirements that apply, and this is this sort of transaction will be treated as a routine share transfer between parties. There may, however, be structuring considerations that need to be taken into account. For example, if the proposal is for the foreign national shareholder to acquire 100% of the capital of the relevant business, a single shareholder LLC will attract a special naming convention as set out in the UAE companies law. It would typically need, the name of the company would typically need to be followed by the words single shareholder company or something, or words to that effect. You will also need to look into whether the memorandum of association of the LLC needs to be updated to reflect the fact that it is now a single shareholder LLC. The corporate governance requirements may need to be altered to make sure that the constitution of the company reflects how it is intended to be managed and run. Equally importantly, consider whether a move to 100% foreign ownership structure will result in the loss of any particular advantages or permits that the business currently holds. For example, certificates of origin for manufacturing businesses, or duty benefits or carve-outs for goods exported from the UAE. This may or may not be relevant, but it's good to pause and reflect on whether this is an issue for the business concerned. And of course, a linked topic in all this is the relevance or the continued relevance of free trade zones. As I'm sure many of you or all of you are aware, free trade zones are abundant and very prevalent in the UAE and are quite well integrated into the UAE economy. And so the question becomes, what is the role or the continued role of the free trade zones in Dubai, Abu Dhabi, and elsewhere, where foreign ownership is now available, 100% foreign ownership is now available onshore? And the answer to that, or at least my view on that, is that free zones will continue to have a role to play in the UAE economy. They may offer special advantages such as logistical or financial advantages. For example, a particular free zone may be very close to a required port. It may offer customs duty efficiency for businesses that primarily trade outside the UAE. A free trade zone will likely no longer be looked at merely because it allows foreign ownership or 100% foreign ownership. And I expect that it will become the case that each free zone will need to justify its value addition and its offering to attract or to continue to attract businesses to that free zone. The floor is open to questions now, to the extent there are any.
Hi, thank you so much for addressing all of these points. One of the questions that have come through is, what does one do if the existing local shareholder doesn't agree to transfer his or her shares to the foreign partner?
Hi, perhaps I can address that.
Sure.
That was raised a couple of days ago, and it's been raised on a couple of occasions already. So we have had situations where, in one instance, the local agreed to be bought out at a reasonable price, and the transfer is going through. And in addressing your issue of the problems of having a sole shareholder, in this case, what the client is looking at is actually having two shareholders, but keeping it 100% foreign owned. So that is an option by having two group companies acting as shareholders. In the other instance, unfortunately, the local partner came and visited the premises for the first time, and instead of agreeing to be bought out, actually wanted his fee increased by more than 1,000%. Asked for a huge hike in his annual fee So that message went disastrously wrong. So in that situation, really, you cannot force the local out. I think you need to look at either really negotiating an agreement with them. There is no way to force him out even through the courts in that system. And if you come to a stalemate, the local partner will always have a tremendous nuisance value through the immigration department, through license renewals, etc. So it does become very messy very quickly. And any solution in that situation would be expensive.
If I can just add, thank you, Bashir, to that. Just one other point: that the starting point has to be that your UAE national shareholder is exactly that. He, she, or it is a lawful shareholder, joint venture partner in your company. So the fact that there are other arrangements that vest economic, financial control, etc., into the hands of the foreign partner doesn't change the fact that the UAE national partner is a legal shareholder and has legal right to the shares that he, she, or it owns in the relevant company. So as Bashir mentioned, it means that you cannot force someone to hand over their shares merely because the FDI regime has been liberalized.
Well, as soon as this law was announced at the end of last year, on the very same day, I was receiving calls in the evening, well into the evening, from several people, or just heard about this law, how do I get rid of my local partner? And, the response was, well, wait and see, because I don't think it's going to be that easy.
Okay, well, any other points you wish to raise or discuss? And if anybody else has questions, otherwise we can, is there anything else, Samad, that you want to share?
I would just add one minor comment is that, as Samad says, have a look at whether being 100% foreign owned is necessarily advantageous. I think down the road we may see certain advantages on companies with local shareholding. Samad, if you agree, perhaps in certain tenders, and perhaps even in taxation when that comes in. It's only a matter of time. And, you may see a situation where wholly foreign-owned companies are taxed differently from companies with local ownership. I'm just speculating, but, we have seen that in other countries. So that is a possibility.
Absolutely, Bashir, agreed. But I think a corollary to that is the question of whether or not, as a result of the new regime, the anti-fronting law, which is on the statute book but has to date not been enforced, will now be enforced going forward. And for those that are not aware of this, there is a statute in the UAE that makes it unlawful to have so-called nominee arrangements. And so far, the position has been that statute has not been actively enforced, and the authorities have tolerated nominee arrangements as an essential part of the business culture in this country. There is a question as to whether that view or that position of the authorities will now change, given that FDI is possible, 100% foreign ownership is now possible for a very large part of the economy. So there is also that consideration to bear in mind in the medium term at least.
Absolutely.
Okay, well, thank you very much, Samad and Bashir. And now we will move on to our next segment on restrictive covenants with partner Stuart Walker and Senior Associate Selectioner Sinan Ayaka. Thank you. Over to you, Stuart and Selectioner.
Okay, thank you very much. Good morning. My name is Stuart Walker. I'm going to be talking to you with my colleague Salakshana about restrictive covenants in the context of this of employment agreements here in the United Arab Emirates. I will give a sort of scene-setting introduction, maybe touch on some of the sort of recent trends and why we think this is important to mention to the audience this morning. And Salakshana will then give you some insight into some of the detail on some of the recent changes that we're seeing in some of the cases that we've been involved in front of the courts. So, in very general terms, you'll be familiar with the idea of restrictive covenants, which are fairly commonplace in employment agreements for senior employees. The reality is that for a long time in the United Arab Emirates, these types of clauses were essentially unenforceable. They may have been in the agreements, but very rarely did you see employers taking action to enforce the terms through the courts. That has changed. That is changing quite significantly, and so this is an area where employers are focusing quite heavily in terms of drafting new agreements for new employees, for new hires, but also looking at the clauses that they may have in agreements with current employees, particularly senior employees. Now, in speaking to you this morning, we're conscious that most of the audience are internal in-house counsel with various large corporate groups, and you will be wearing your GC hats and sitting through this presentation to understand the implication of this for your company and for the employees in that business. You may also, as individuals, have restrictive covenants in your own employment agreements, and you may want to understand how that works when you move on to your next new exciting job. So we will touch on both the issues from an employer perspective, but also from an employee perspective. So just to give a little bit more detail, what do we mean by restrictive covenants? Essentially two areas: non-competes, which is where the employee agrees that after they leave they will not join a competitor business, and non-solicitation, where they say that when they join a new employer, they will not attempt to solicit away existing clients of the first company or existing team members. So non-compete and non-solicitation. And famously, they should be limited in time and geographical scope. And it's the detail is important in terms of how tightly these clauses are drafted, because if they're too broad or too aggressively drafted, they're simply unenforceable. The final point I want to sort of just highlight in terms of how you think about these agreements, these clauses, relates to the two times when they will be looked at in the agreement. The first time is when you are hiring someone and you put an employment agreement in front of them, and it includes restrictive covenants. That will be a negotiation point for some new hires at that stage. And clearly, at that point, you don't want to lose a good hire by putting a clause in that's too aggressive and scares them away. The second time, the more interesting time that you're going to look at these clauses, is where someone is threatening to leave or has left to a competitor or has taken clients or team members with them in breach of a clause. At that stage, you want to look at it and try and understand what your remedies are at that stage. And that's the sort of work we have been involved with at Afridi Angell recently in the context of senior employees leaving or threatening to leave and taking team members with them and or sensitive client information. So these are the trends. These are the issues. I'll hand over to my colleague Slukshana to give you a little bit more of some of the detail there.
Thank you, Stuart. Lakshmi here. Good morning, everyone. Just to follow on from what Stuart said, I would focus more on what remedies an employer would have in the event you're faced with a potential breach or threat of a breach of restrictive covenants by an employee or a group of employees. Because we've seen that after the mass exodus that happened in COVID-19, there's been a lot of people jumping ship or moving to competitors, taking along entire teams with them in what we call team moves. And it's happening both in the DIFC and in mainland Dubai, which brings me to an important separation between the two legal systems. Now, as we all know, the onshore legal, the court system follows a civil law system of courts, while the DIFC and the ADGM follows a more common law approach. And that distinction really brings out the biggest challenge that an employer based onshore outside the DIFC or the ADGM would face. And that is the lack of what we call an injunction. Now, the most important remedy, or what an employer would immediately try to seek when threatened with something like a team move, is immediate measures to stop the employees or the group of employees leaving. And in most jurisdictions, the remedy for that would be an injunction, an order from a court preventing someone from doing exactly what they're threatening to do. Unfortunately, as you know, Dubai courts and the other onshore courts do not have the remedy of an injunction, and an employer is faced with really going to courts and threatening to sue for damages for breach of restrictive covenants. Now, if you do follow that route, you will spend a lot of time in litigation, and at the end of the day, the court would be guided by the provisions of the UAE Civil Code, for instance, which gives brief guidance on what a restrictive covenant is and how it should be defined. And the brief description is that a restrictive covenant should be limited to the extent necessary. So the court would then conduct a factual exercise of really trying to figure out what the employee was doing, whether the restrictive covenant is broad enough or narrow enough to stop him from trying to do what he now intends to do. And we have very mixed results after years of litigation before the local court. So instead, what a new trend that's emerged is for employers to really resort to criminal measures. This is again outside the free zones of the ADGM and the DIFC courts, which I'll get to later. Now, both the UAE Penal Code as well as the Cyber Crimes Law, which came into effect quite recently, make provisions for the illegal transfer of information, or what we call stealing information or trade secrets, and then providing them to a competitor. Now, so employers can resort to the articles in the Criminal Code and the Cyber Crimes Law to threaten the employee that if you intend to take our trade secrets to a competitor, we will certainly commence criminal action. And that threat of criminal action really does have some teeth. As you all know, the Dubai police tends to be aggressive in how they pursue criminal complaints. But a word of caution is that once you do file a criminal complaint in the Dubai police or the Dubai criminal courts, it takes a life on its own. And neither the employer or the employee will have control of where it goes. And the burden of proof for an employer to prove that there's been a dissemination of trade secrets, it's quite high. Not only would you need to show that the employee in question took the trade secrets from your servers or your offices, but you'd also need to show that a competitor or the employee illegally used that for his benefit. So that's a two-pronged test, which in our experience is quite difficult to prove, and again comes with a lot of delays. So you would not have that immediate remedy that you would have elsewhere. However, it definitely makes a lot of sense for an employer as a first step to threaten the employee of all these potential action in the concept of in the onshore legal system. Moving to the DIFC and the ADGM, where things are a bit more exciting, you would always have, as you know, there are common law systems, and you have the remedy of an injunction. And an injunction in the DIFC or the ADGM is fairly easy to get in light of a very clearly worded restrictive covenant, and in light of facts which show that the employee is imminently about to leave the employment in breach of their restrictive covenants. Now, we have managed to get hearings in the DIFC courts within a span of 24 hours to get urgent relief, and that relief certainly is available. The DIFC and the ADGM common law system of courts not only offer injunctions against employees, but also against the potential new employers. Now, that's called a springboard injunction, and Afridi Angell were the first law firm to actually apply for a springboard injunction in the DIFC courts about 3 years ago, which effectively sought to prevent the new employer from hiring the employee because he was taking our trade secrets and was leaving the company in breach of restrictive covenants. Where things get even more grave, I would say even more dangerous for employees in the DIFC and ADGM sector is if they are faced with a threat of conspiracy. Conspiracy in the context of employment law is where, like Stuart said, there are two types of restrictive covenants: the non-solicitation provisions and the non-compete. Non-solicitation is where is where you promise, an employee promises not to take any other employees with him. Now, if it is proved that an employee induced other employees to join him, to join a competitor, there is a cause of action for conspiracy to injure the business that he was leaving, and that could result in massive claims against the employee. So the employer has that remedy of pleading what is known as a conspiracy claim against the employee, and the threat of that claim itself is quite substantial, and an employee should really take that into account. That is broadly that broadly covers the sort of remedies that are available on onshore and DIFC under the two regimes. Unless Stuart, I've missed something.
No, thank you. That's a very good recap of where we are. I wouldn't want to suggest that we would always advise parties to rush to court to enforce these types of provisions. As ever, having the provisions in the agreement is the starting point for a negotiation amongst the parties, and that's what we see happening in practice. In reality, you have these provisions. There is then a negotiation between the old company, the new company, and the employee as to how long they will sit out of the market, how long their gardening leave will be, which clients they'll take with them, which clients they will not talk to, etc., etc. But having a robust clause in your agreement gives you a stronger hand, obviously, in those negotiations. If you draft provisions which are clearly never going to be enforced, then there is no negotiation. Similarly, if you don't have a clause at all, you have no protection. So you want to have provisions in the agreement. You want them to be a reasonable expectation that they could be enforceable as drafted. But that is really the starting point of a negotiation in practical terms in many cases. That is what we have to say, but we're very happy to take questions if anyone had any specific points they wish to raise at this stage.
Thank you very much, Stuart and Sulakshana. I do have a couple of questions. The first one is, what is the right time period for a restrictive covenant?
Do you want that in months or years?
I suppose, it didn't quite specify, but why don't you say, how about months?
So there's really no right answer to that question. It all depends on the wording of the restrictive covenant, what the employee was actually doing, what sort of trade secrets he was exposed to, the competitor that he's about to join, whether it overlaps with his duties with his previous employer. And what we've realized is in both the DIFC and in onshore courts, it's all up to the courts to interpret the effectiveness and the reasonable length of a restrictive covenant at the end of the day. And it's a very fact-heavy matter. And there's some guidance in common law and in the UAE Civil Code, as I said earlier, but it all depends on whether the restrictive covenant was reasonable to the extent necessary to protect and safeguard the interests of the employer. Anything to add to it?
No, that's the first one.
Anything over 6 months is just going to be really hard to enforce, to be honest, practically.
I see.
That's really like the benchmark. We have instances where just to ensure protection for the employer, you would have a paid garden leave period whereby the employee would not be allowed to come into work, but he'd be paid his salary for a certain amount of time, and thereafter the restrictive covenants would take effect. So you could potentially have up to 9 months, including paid garden leave periods, where the employee is not allowed to join a competitor. But again, all of this is very fact heavy.
Okay, well, thank you. Another question, should the restrictive covenant be included in the offer letter?
Yes. No reason to try and hide the fact that you're going to include a restrictive covenant. There's a move to include all key employee employment provisions in the offer letter itself. There's no point trying to hijack or surprise someone later in the process. So I would encourage people to include, in broad terms, the terms of a restrictive covenant at the time of making an offer.
Okay, thank you. And is it true that confidentiality requirements can be lifetime, or should they also be time controlled?
Yeah, I think when people start saying any sort of obligation should be lifetime obligations, you've got to raise an eyebrow at that. I think putting in some sort of realistic time frame is sensible. If there was a lifetime prohibition, I think you would just say that's unenforceable.
Especially in the employment context or in the context of a restrictive covenant, to have anything last a lifetime is going to be pretty difficult. Alternatively, you could have perhaps a confidentiality agreement that stands alone from the employment contract itself, if there's very sensitive information. But then again, the effectiveness of that can also be challenged. But that's definitely a step further to safeguard any confidential information.
Yeah.
Okay, thank you. Another question, what is an appropriate geographical limit for a restrictive covenant in an age where we work remotely?
That's a very good question, and it's something we've been looking at fairly closely in a couple of recent cases. Historically, these types of provisions had to be limited in scope. They had to be reasonable, and one of the parameters was geography. You could limit someone to not compete with you in the UAE, for example, or perhaps the GCC or the Gulf region, and,
yes.
and then you get into definitions as to what the territory actually is. But that, and there is case law on what is reasonable. But that all assumes a sort of slightly 20th century working model where people come to a physical office, sit at a desk, and deal with clients face to face in one country. We don't work like that anymore, and so these geographical limitations start to look slightly artificial. And I think as we draft them for clients now, we're trying to be a bit more conscious of the fact that people may sit in one country and deal with clients in another, and your non-compete has to deal with that. Well,
thank you very much. That's very, Another question is it correct to state that irrespective of well-worded non-compete clause in employment terms, it is impossible to stop an employee joining a direct competition?
No.
We are not a free zone company. There has been no success rate in courts for employers unless it's a fraud-proven factual data.
Yeah, never say never, and nothing's impossible. But there are real difficulties in stopping someone moving outside the free zones. Now that doesn't mean that you can't get compensation or you can't have other remedies, but actually stop someone moving sideways. It's going to be difficult.
Outside the ADGM and DIFC, because of the unavailability of injunctions, you wouldn't see that immediate relief. So yes, it would be difficult to immediately stop that employee leaving, but there would be remedies later on in damages, like Stuart said.
I mean, in the past, there was immigration remedies in terms of objecting to the transfer of work permits, etc. That has largely fallen away these days.
I see. Okay. Thank you. And one more, actually a few more. What about non-solicitation provisions? Are there any requirements for this? For example, should this be restricted to same trade for a certain territory, etc., for a limited period of time?
Correct. Yes, the non-solicitation clause will need to be limited in some ways, in the same way as the non-compete clause. It has to be reasonable. It can't just be a blanket non-solicitation forever. So that there has to be limitations if it's to be enforceable.
The narrower, the more specific a non-solicitation provision is, the more easily enforceable it becomes.
I see. In order to enforce, must the employer be able to prove actual damage?
In the onshore side of things, that damage would be necessary or very helpful if you're going down the criminal route or the civil route. But in the free zones, the DIFC and the ADGM, damage is not entirely necessary for you to get an injunction. At least it's assumed that if they do breach the non-compete or non-solicitation provisions, there would be damages. So that's not a main requirement in the free zones.
And just, although the need to sort of prove damages is something to think about, that is a sort of secondary consideration if you're still at the negotiation stage. If someone's threatening to move or has moved, but you're negotiating the terms of their move, you're still negotiating. You're not having to present evidence of damage to a court. So there can be a little bit of negotiation around that, or a little bit of bluffing, frankly, as to the actual damage that has been suffered or might be suffered while you're negotiating.
Okay, thank you. Can onshore-like company agree through a separate non-compete agreement or undertaking with employees for DIFC laws in order to take advantage of remedies available under common law or DIFC ADGM courts?
You can try it, and I think some of our clients have tried it. There is a real risk that when you attempt to enforce it, the DIFC court would say this is an employment issue to dealing with an onshore company, and therefore it's not within the jurisdiction of the DIFC court. So broadly, we don't think that's a very good idea.
It's recommended that perhaps if you really want to go that route, make it sound more like a very purely commercial contract rather than anything to do with the employment relationship, like an independent standalone confidentiality agreement, for instance.
Yeah, and if you were to do that, there may need to be separate consideration for those specific provisions.
Okay.
And what would be the legal value of a restrictive non-compete clause on an offer appointment letter in an LLC company? Does that make
Well, yeah. I mean, if everything that we've said already would apply there as well. LLCs, onshore LLCs, can include restrictive covenants in their employment contracts, but caveats as to the enforceability, as we've mentioned before.
Okay, for an employment contract within mainland Dubai, can the employer get an undertaking executed from an employee wanting to exit for specific non-compete provisions and a penal provision and a penal provision and agree on jurisdiction as DIFC instead of mainland Dubai?
I think it's a similar question.
Yeah, it's a similar question, actually. Yeah.
No, is the easy answer.
Yeah. Okay. If are there any other points? If anybody has any have any questions or if are there any other points you want to raise or Stuart and Salakshana as ending comments, perhaps? Or that's pretty much it.
No, just thank you everyone for the opportunity for us to highlight some of these issues. As we said at the beginning, the trend is for employers to look more closely at these provisions and to think about enforcing them, or certainly have discussions as to the enforceability of them with exiting employees. So it's worth getting the drafting right at the outset, because that gives you a much stronger hand for the negotiations that happen further down the road.
In fact, I don't know if you don't mind, there are a couple of other questions that just came through. How do you ascertain the damages for non-compete covenants?
So in the DFC concept, it's based on the actual damages, and that should be fairly easy to calculate. For instance, if a high-level employee brought in a certain amount of business per year, and he's breached his non-compete or non-solicitation and taken that business elsewhere, that's a direct damage to the company. Similarly, if he's taken other employees with him, any revenue generated by those employees would also would be lost to the company, and that's a damage. A similar test could potentially be applied in the onshore scope things as well. But in onshore courts, we see a tendency for the experts that are being appointed, for instance, to really require proof of the damages at a higher level than in the DFC court. So it'll need a lot of documentary evidence and perhaps an expert's involvement to really quantify those damages. And what I said earlier about the benchmarks or the guiding principles would still apply. I think that's right.
Okay. And can employers and employees agree on penalty for breach of non-compete, and how effective will it be?
Now, the civil code specifically says that now this is similar to a liquidated damages clause, for instance, in a construction contract. And the UAE Civil Code says that any set amount of damages, which is set in a contract between the parties for a breach, for instance, can always be looked into by a court. So there is a potential that a Dubai court or onshore court would still require actual proof of damages rather than just simply taking the figure that was set out in any contract. In the DIFC, where the courts tend to really honor the contract between the parties, there is a potential for that to be upheld, but it's yet to be tested.
In practice, I've never seen a pre-agreed penalty clause that is actually an accurate, correct number that the employer thinks is the correct number when you actually come to enforce. It's either set far too high or far too low, if you see it at all, and in reality you don't see it very often.
Okay, well, on this note, I just want to thank you all. Thank you, Bashir, Abdussamad, Stuart, Sulakshana, for sharing all this information with us. And want to thank everyone for joining us this morning. And thank you again for the ACC Middle East North Africa for organizing and hosting this webinar. And as I mentioned earlier, this is recorded, the webinar is recorded and will be posted on our website and will be sent to all of you. The recording will be shared with all of you. And if you have any additional questions, please feel free to reach out to us. We are available and you can find our contact details. Some of you already have our contact details. You can find it, you can send it to the ACC or to our lawyers directly. Thank you very much for joining and have a great day. Thank you.